Colleagues, let's continue after the break. We are continuing our special joint meeting because of there is no interpretation. Can you hear interpretation? 1, 2, 3. Interpretation checking. Can you hear me? Let's announce a break. Is it back? Can you hear it? Mr. Robert, can you hear interpretation? No, they are saying that they cannot hear. I'm announcing a second attempt. After a technical break, we are continuing our meeting. I will be presiding over this meeting because of Mr. Andrei Patin being busy because of his job duties. And please invite candidate for the position of the judge of the High Corruption Court, Smal Inna Anatoliyivna, into the room. I'm sorry, Inna Anatoliyivna. Good afternoon. Please take your seat. We are considering the issue of compliance of the candidate for the position of the judge of the High Corruption Court, Smal Inna Anatoliyivna, with the criteria set out by Part 4 of Article 8 of the Law on the High Corruption Court. We have present members of the PCAE. Robert Heinbruch-Heisen, Chair of the PCAE, Norman Aas remotely, Mary K. Butler remotely, Gabriela Yotkaida-Granskiene also remotely, John J. O'Sullivan, and Jessica Lott Thompson. Bless you. I'm saying the truth. We also have present HQCJ members Михайло Богоніс, Людмила Волкова, Ярослав Дух, Роман Кадисюк, Олег Колюш, Ігор Кушнір, Олексій Омелян, Роман Сабадаш, Руслан Сидорович, Сергій Чумак, and Halina Shevchuk. Other members of the HQCJ will join us a bit later. Do you understand the composition of the Commission? I'm explaining your rights to you now. When you're answering, please switch on your microphone. You have the right to request recusal of Commission members, provided that there are grounds set out by the law, to submit motions and to provide explanations upon permission of the presiding chair, to express your considerations and objections, and to challenge decisions in instances set out by the law. I would like to emphasize that we are not considering any new material submitted by the candidate. If previously there was an opportunity to submit such materials, but the candidate did not provide that to the PCAE or HQCJ. If there are circumstances that can significantly impact the decision-making upon the initiative of at least 3 members of the PCAE or Commission by the majority of votes of the PCAE and HQCJ, there might be taken the decision on acceptance of additional materials, provided that at least 3 members of the PCAE have voted for it. Do you understand your rights? Yes. Do you have recusal requests on motions? No. None. Okay. The rapporteur regarding you is Sidorovich Ruslan. Please, over to you. Thank you, Mr. Oleg. So, a brief report about you. With the decision of the Commission dated June 3rd of 2025, there was announced competition for filling in 23 vacant positions of judges of the High Corruption Court and Appellate Chamber of the High Corruption Court. By the established deadline, the Commission received an application from Inna Anatoliyivna Smal as a person meeting requirements of paragraph 1 of Part 2 of Article 7 of the Law of Ukraine on the High Corruption Court, that is, having at least 5 years of experience serving as a judge. With the Commission decision dated September 18 of 2025, Smal was admitted to the qualification evaluation and participation in the competition. With the Commission's decision dated September 19 of 2025, there was a scheduled qualification evaluation within the framework of the competition for vacant positions of judges in the Hague and Appellate Chamber of the Hague. With the decision of the Commission dated September 19 of 2025, there was appointed qualification exam and the sequence of its stages was determined. With the decision of the Commission dated February 4 of 2026, the overall results of the first stage of the qualification exam were approved. Based on results of the qualification exam, Madam Smal got 351.64 points and was admitted to the second stage of the qualification evaluation, that is examination of the dossier in interview. A brief information about the candidate's qualification. In 1996, Smal graduated from Yaroslav Mudry National Law Academy of Ukraine and was awarded the qualification of specialist in law. And the candidate has provided a copy of her specialist diploma dated June 29 of 1996. Also, Smal provided a copy of the diploma of the Doctor of Philosophy dated July 25 of 2025, issued based on the decision of the Specialist Academic Council of the Penitentiary Academy of Ukraine. According to the diploma, the candidate completed her dissertation at the Penitentiary Academy of Ukraine in accordance with Educational and Scientific Program Law and obtained a Doctor of Philosophy degree in the field of law. The topic of her dissertation is Theoretical Foundations of Information and Practice of Applying Electronic Evidence in Criminal Proceedings. According to the materials of the candidate's dossier, she does not have the academic title. Brief information about the professional activities of the candidate. With the decree of the President of Ukraine dated December 27 of 2001, Madam Smal was appointed for a 5-year term to the position of Judge of Sosnitsa District Court of Chernihiv Region. With the resolution of the Parliament dated April 5 of 2007, Madam Smal was elected to the position of Judge of Sosnitsa District Court of Chernihiv Oblast indefinitely. So, according to the materials of the dossier of the candidate, Madam Smal held the position of the President of Sosnitsa District Court of Chernihiv Region during the following periods: from September 28 of 2007 to September 27 of 2012, from May 16 of 2013 to April 11 of 2014, from April 22 of 2014 to April 21st of 2015, from April 22nd of 2015 to April 21st of 2017, and from April 26th of 2017 to April 25th of 2020. That's a brief report. Over to you, Mr. Chair. Thank you, Mr. Ruslan. Is everything correct? Yes. Okay, thank you. So then I'm passing the floor then to the PCIe members. Mr. Robert, over to you.
Thank you, Mr. Chair. Over to Jessica because she is the rapporteur.
Thank you, Mr. Chairman. Good afternoon, and congratulations on reaching this stage of the competition. There are many steps and a great deal of effort that goes into reaching this stage, so I will offer you my congratulations. I'll introduce you first to the members of the PCIe. First, I'll indicate up on the screen to the far left is Mary Butler, who is a prosecutor with the Department of Justice in the United States. In the center, Norman Aas, who is a former prosecutor and a lawyer in Estonia, and Gabrielle to the far right, who is a Chief Justice in the Criminal Division in Lithuania. And then here in the room, we have to my far left is Mr. John O'Sullivan, who is a former judge from the United States, and Robert Broekhuizen, who is a former prosecutor and attorney in the Netherlands. And my name is Jessica Lott Thompson. I'm a former prosecutor and lawyer in Canada. So I'd like to just first, before we begin, if you have any questions about the procedure or the process, please feel free to ask. Ні, дякую.
No, thank you.
And I'll remind you that we are working with an interpreter, so please always speak closely into the microphone. You can feel free to leave it on, and then you don't need to worry if you turn it on and off. Also, I will remind you that this video interview is broadcast, and we have already had the opportunity to send you written questions that you have responded to in advance and provided us with documents to support your answers. So many of the questions that I will ask you today are familiar to you. They're about topics that you have already exchanged information with the PCIe. And so your answers may sometimes be repetitive. So please know that if I am asking you a question, it's not because we do not already have your answer. And you can feel free to repeat the answers that you have provided in writing, but to just make them brief in recognition of time management, which is a judicial skill, that we will provide you this opportunity to demonstrate the skill of time management during this interview. Okay, so I'll begin with questions related to your motivation and your professional readiness to serve as a judge of the High Anti-Corruption Court. Can you please describe your motivation? Why did you apply for this position?
My desire to work in the High Anti-Corruption Court is a reasonable and balanced decision. I am considering the work of judge of that court as a logical stage of my personal and professional development. I have experience at the position of the judge of 24 years, so that's quite an extensive experience of work. Actually, for 8 years, I have the right to go to retire. But for myself, I'm choosing. I have a high motivation to continue working. I have selected for myself to continue my professional activities. However, work in this particular court is considered by me as my development, as my professional development. And moreover, I have the desire to exercise my conviction, inner conviction, that it is important to have independent judiciary in this particular court. So I want to implement that for myself as a judge.
Thank you. I'd like to get a little bit more specific about the aspects of your judicial experience that you consider the most relevant to this type of position. Specifically, how does your judicial experience help you to adjudicate corruption cases? Please give any specific examples regarding previous cases that you have dealt with involving corruption, abuse of office, or other complex economic crimes. Also, I will let you know you're not required to disclose anything that is private or otherwise the specifics about a case, but please describe the specific areas of law and judicial skills that you used in dealing with those cases.
Thank you. I considered and continue considering cases in civil and administrative offenses, administrative cases, criminal proceedings. Also, I am an investigative judge and the judge dealing with juvenile cases. So accordingly, as a judge, I worked with different standards of proof, which is relevant for the practice in the Hague because they consider also civil cases apart from criminal cases. The civil cases are about unjustified assets. They also have administrative cases according to the law on sanctions. With respect to the consideration of corruption criminal offenses, and I considered these cases. I did have them in my caseload. In particular, I can mention that I had cases under Part 5 of Article 191 of the Criminal Code of Ukraine. These were cases on appropriation of property by means of abusing positions in especially large amounts. Also, I had a case under Article 369 of the Criminal Code, that's unlawful benefits provision. Also, Article 368, that's receipt of unlawful benefit. Also, I had a case under Part 2 of Article 191, that is embezzlement by means of abusing official position. As of now, I have some criminal cases in corruption, criminal proceedings in my caseload. That's Article 364 of the Criminal Code of Ukraine. That's 4 defendants in that cases. So that was committed by a group of persons, and there are several episodes in that case. That's quite an extensive criminal case. According to the register, the bill of indictment contains 25 volumes of case materials. I also have another criminal proceeding, that's Part 4 of Article 191. That's in that proceeding, that there is also Article 366, that is, and aiding and abetting from Article 358. That's also embezzlement of property by means of abusing official position, also quite an extensive criminal proceeding. There, according to the case materials, there are 15 volumes of materials. Also, in my caseload right now, I have another case. That's Part 2 of Article 191, also appropriation of property by means of abusing official position, and I'm also considering this case now. You also asked about me using my experience of work and how it can facilitate my work in the anti-corruption court if such a decision is adopted by my appointment. I have quite a long period experience of work, and of course, I've encountered such matters that quite often it was necessary. A judge needs to preserve emotional calmness to know how to respond to some extraordinary situation. It's necessary if you are entering the court hearing. There are quite unexpected motions, but you have to be ready for everything like that, and you have to know how to control your emotional condition. I understand the peculiarity of working in the anti-corruption court quite well. I understand that that court is under constant attention from the public, and there are quite high expectations from this court. And also that's an opportunity of political, informational pressure on judges as well. So I understand that apart from professional knowledge that a judge needs to have, it's also necessary to be able to resist that pressure so that you would have emotional inner calmness, so to say, and so that you would know, so that you would understand your main goal, and that is to adopt court decisions according to your inner convictions based on the law and evidence studied.
Thank you very much for your very thorough answer. And also thank you for providing the detail about the specific cases and the size of the number of volumes. It's very helpful. Can you please share with me, based on your experience as a judge and your knowledge of anti-corruption law and anti-corruption related issues facing the judiciary in Ukraine, what are some of the main challenges that judges face when dealing with high-profile corruption cases? You've identified already this balance of emotional skills with knowledge, but can you identify any other issues that are serious that judges must deal with in Ukraine in relation to complex anti-corruption?
Well, for me, first of all, that's a huge amount of evidence, and evidence is related to the analysis of financial documents, and accordingly, it's necessary to have knowledge in that sphere. And besides, That's, for example, I'm encountering the situation that now I'm considering lots of items related to the covert investigative actions, and I have to know how to analyze this data, because that is very closely related to the electronic evidence. And for example, the peculiarity of defendants in this criminal offense, these are people who are holding some position, who have some influence in the society. And that's also another trait that makes these proceedings different from others.
Thank you. I'm going to move on now to some technical topics. Specifically, let's talk first about your administrative position as the head of the court in Sosnetsky District Court. I understand that you have held the position of head of the Sosnetsky District Court continuously between 2007 and the year 2020. This means that the administrative role has been in your hands for nearly 13 years. Can you explain why this remained the case and why no other judge potentially sought the position during such a long period?
Yes, thank you for your question. At first, when I was appointed to the position of the judge, that was the decision of the Council of Judges of Ukraine. So this was not the meeting of judges. Then, starting from 2007, I worked in the court on my own. That is a problem of such small courts. I worked until 2010, I think. So I was the only judge in that court. Then there was a decision that was the decision of the High Council of Justice also. Not the staff of the judges, but that was the decision of the High Council of Justice. Then we had a decision of the meeting of judges in 2014. There, before I was appointed in 2013 for 5 years, but then there were amendments to the legislation, and it was necessary to decide the issue on the selection of the head of the court by the meeting of judges. I was selected like that by 3 times. At first for 1 year, then it was for 2 years, and then for the 3rd time I was elected for 3 years. Why did it happen like that? I was answering, and I was given references to the legislation as to why I held this position for so long, but it was in line with the current legislation. That's the law on the judiciary, and then the law on the statutes, judges, and judiciary. And why did it happen like that? As I was saying before then, I worked on my own. Then young judges joined our court. 2 judges came to us. Our court is small, so we have 3 judges only. And I would like to point out that these judges were focused on gaining experience. They were not interested at all in holding this administrative position, and they did not nominate themselves. And if there were no other candidates, I, as the person who has the longest experience in the court, I would still continue performing functions of the head of the court. So it could not have happened differently. So this way, it was happening like that.
Thank you. I can appreciate that being the sole judge in a jurisdiction, you would have to handle many complex issues, both administratively and in your judgments alone, which is a challenge that it sounds like you dealt with for many years. When these other 2 younger judges joined, can you explain how, or if you took any steps, even though there was this formally lawful repeated appointment, did you take any steps to avoid a perception of excessive concentration of administrative influence in your position as the head judge? Were there any steps that you could take to try to avoid a perception of undue influence, or sort of concentration of influence, I suppose, is a better way to describe it?
As I've mentioned, that's a small staff of judges. We always discussed all the matters together. There were no matters that would cause any contradictions or arguments. And besides, as the head of the court, I was obliged, and I did that, to hold a meeting of judges every 3 months, according to the law on the judiciary and status of judges of Ukraine, and we were discussing all important issues, even if it was necessary to hold some irregular meeting. We always did that at the meeting of judges. We had very friendly staff, and all the matters were resolved unanimously, and there were no contradictions.
In 2020, the year 2020, you ceased to serve in the role as the head of court in Sosnitsky, and a new head of court was appointed. I understand that there was some issue potentially that occurred relating to your office accommodations at that time. Can you please explain that situation or describe if there was any issues that took place after you were replaced as the head of court in 2020?
Can you please, which issue emerged? Can you please repeat, because I do not quite understand.
You reported a situation of potential interference related to your assignment to an office that had inadequate physical circumstances for you to complete your work. Can you please explain this situation of potential interference with your work and provide some explanation about this concern?
Yes, that question was asked to me for written explanations. Then I could have provided additional documents, but I can explain it as follows now. Once a new head of the court was elected at the meeting of judges, sometime later, the meeting of judges took a decision that the office room for me as a judge would be the office room where the head of the court apparatus and the court consultants were sitting. That situation, we tried to resolve that situation. I addressed each of the judges, and together with the head of the court apparatus, we addressed the head of the court to resolve that. So each judge has quite spacious offices. They're quite big, and no office is different from the office of another judge. So these are big rooms. And I provided back then, when I was submitting this application, I also provided the respective document that office where I was located as a judge was not the office of the head of the court, according to the design and the court plan. And I started working in that office even before I became the head of the court. So we had the head of the court who retired, and that was the office where, and it was not the office of the head of the court. That situation was not very pleasant for me, but when I'm analyzing this situation now, many years have passed since then, I'm asking myself, would I do the same, or maybe I would have acted somehow differently? And for me, the answer is the same. I would have done everything in the same way, because I believe that the role of the head of the court is about resolving conflict situations, because before then we have never had any conflict situations, and I do not even understand why it emerged. And it was a pity for me to be in that situation, but I do not know. I did not know what to do, so that's why I still thought that it was interference with my work as the judge, because I was supposed to share that office with 2 court employees when there were 3 offices. So that situation was not clear for me. Again, I would like to emphasize that I tried resolving that before I submitted that application.
In your view, do you feel this was only a workplace dispute, or was it a deliberate abuse of administrative authority towards you?
You know, I would not want to give a detailed answer to that because the colleague cannot respond to some of my accusations or some of my words. That would be not very correct from my side to do that. When I do not I did not feel any moral duty to respond to that because you have to work in the staff with a healthy atmosphere. But I would like to point out that my application submission of this application, and it was decided that there was no interference with my work as a judge, but it facilitated improvement of our relationship in the staff, and we have not had any issues since then. If we look at the work and how we continued working after that, no, we have not had any conflict situations after that. So we have found some common grounds with the head of the court, and when my powers expired, I told him that I would support him in all the issues. So I knew how the Chancellery Office of the court worked. I even took part personally in summarization, generalization, in statistical work of the court.
I'll stop you for now and we can move on to some other topics. I'd like to talk with you. Oh, sorry. It's okay? Перекладач працює? Так. So I'll move on to some of another question related to Article 130 cases and issues related to the expiry of limitation periods. I understand that during your 24 years as a judge, you have handled many cases related to Article 130, and that some of those cases handled by you were closed due to expiry of the limitation period. I will note that you have provided information about, detailed information about the cases that we have identified for you, and that between 2014 and 2025, you considered over 400 Article 130 cases, close to an exact number of 403, and that a total number of 16 of those cases were closed due to expiry of the limitation period. So 16 out of 403 is actually quite a small percentage. It's much less than 1%. It's really a very, sorry, math is not my strong suit, but it's a very small percentage. Can you please explain personally what you do to prevent expiry in cases related to Article 130 and why some of those cases were delayed in your case, in your situation?
So when I received that question, I turned to the statistical data of our court because I needed to analyze 6 cases. I analyzed all the cases and selected the cases I had under my consideration. So I found that I had 403 cases under Article 130 that were closed due to, and 16 of those were closed due to expiry of the limitation period. And I provided you analysis for each year, and I'm of course not going into details because of the time. In 2014, 88 cases were considered. And if we take different years, from 2017, there have been no closed cases due to expiry of the limitation period. And I would agree with you that this is a rather insignificant percent, but even for that percent, I had objective reasons. As a court chief, I and the court took all the necessary steps to resolve the cases and defend the interests of the party. And I have heard that there are such issues in other courts too. And when I got notification that the notice had not been served, then I would send a request to complete the documents in order for the protocol of the administrative offense to contain the address, residence address of one of the parties. And I stated the dates in my responses. There was no big gaps between the pre-trial and trial. In some of the cases, the limitation period were over, expired. And of course, it was clear that there was no other choice for me to close those cases due to expiry of the limitation period. There was no other choice. And I believe that serving a timely notice to one of the parties is one of the parts of the right to a fair trial as set out by the European Charter on Fundamental Rights and Freedoms. And I approached this issue on multiple times, and whenever I was a court chief, I tried to do my best to implement the fair trial principle and to ensure the party has a possibility to stand before court and explain themselves. And this is an important part of fair trial, in my opinion. In 2017, there was no closed cases due to expiry of the limitation period.
Thank you for your answer. I will move on to another issue. During your time as a judge, you have also completed your PhD while working full-time. I would like to ask you a little bit about to explain how you balanced your work, life, and studies as a judge. And then also for you to please describe the precise subject of your dissertation. Please introduce us to the topic of your dissertation.
All right. I would also like to state a couple of things about why I started doing research, why I became a postgraduate student, started my scientific research. At a certain stage, when you have a big bulk of working experience, you start feeling burnout. You don't feel that you are developing professionally. Therefore, I chose to engage in academic area. So the title of my thesis was approved at the session of the academic council, and I was discouraged from taking that topic because it was a complex one, but I wanted to understand it better. And I knew that the outcomes of the thesis could be used in practical field. So how did I write my dissertation? 2019, when the topic of my the topic of my thesis was approved, in late 2019 it happened. I started working at this text from 2020. I refreshed my memory of the previous articles. I published them in early 2020. So how I managed to combine all of it, I would, as you mentioned, I organized my time. So I did some time management in the first place. Then self-discipline was also key. And I wrote that dissertation for a long time. I finished it in March or April 2025. So it took me a while to complete my thesis.
I'm going to just cut you off there because there's just a couple more issues that I'd like to deal with, and we're getting close on time. So in your dissertation, we have identified 3 separate instances where there are some absent citations or errors and some overlap with the dissertation of somebody named Ratnova. Can you please describe your response to these concerns that have been raised already with you, and explain why how these errors affect your dissertation?
Let me give you a broader answer to this question because it matters in order to prove my integrity.
To limit your answer to approximately 2 minutes or less because we are running very close on time.
All right, thank you. Then I will try to narrow down. So I would like to draw your attention to the questions that I had been asked. So that dissertation was provided to me. In one of the pages of Ratnova's dissertation, she refers to the authors she cited when she defined the electronic evidence. Sirenko, Хоменко, Часовий, Котляревський. At the same time, in my dissertation, you've got references to these authors. And beyond references to these authors, the structure of my thesis by no means bears similarities in analysis of these authors as pertains to the definition of the key term. So my thesis, chapter 1, 2, the notion of electronic evidence, I consider this issue with the account through the comparative method, and my task was to provide a definition of electronic evidence. And without turning to scientific works of other authors, you cannot analyze how those authors had defined it before you. And beyond some coincidences that we may find across all of these authors,
I'm going to have to stop you now because we have one last issue to discuss, and then we will be out of time. So I'd like to ask you about some of your tax returns, your declarations, and issues related to your former husband. I understand from your written answers to us that your marriage was legally dissolved on November 10th of 2004. However, in your 2012 declaration, you have still referred to Mr. Smal as your husband, and that it was actually some additional years until April of 2013 when you received a formal divorce certificate and the complete dissolution of your marriage. Can you please explain? I am unfamiliar as a foreigner with family law in Ukraine. Can you please explain why there was this period of 9 years between 2004 and 2013 for your separation and the conclusion of your divorce proceedings?
Yes, indeed. We dissolved our marriage in 2004, and later we got a certificate of the divorce. Why it happened so? There are proofs of that, the court rulings, the appropriate court regarding joint household. So after the actual divorce, we continued living together. In the actual marriage, we were actually married. During that time, and we didn't need to get a certificate of the divorce. Under the law, under the law, the court ruling proves the fact of the divorce. And in all my declarations, if you take them, I stated that I had a civil marriage. Therefore, I found myself in this situation. And in order to prove the fact that we actually lived together, I turned to the court, and there is the appropriate court ruling that says that during that period we had a factual marriage. So this is how it is called under the law. You also asked why my declaration stated the period of factual marriage. We had common property, and I declared that property in my declarations. It started from 2010, and in each declaration, I indicated that property as the property belonging to my husband, because he was the nominal owner, and it is registered in his name in the register, property register. From late November 2012, we did not live together, and the declaration for 2012, 13, and 14 it did not contain that property owned by my husband, because he no longer was a family member of mine. And if you take the paper declaration, it was impossible to reflect the jointly owned property. It would be either owned by the family member or by the declarant. And in 2015, we had still paper declarations. And then in late 2015, we switched to the electronic declarations.
I'm going to ask you one other question. There is a land plot that you were granted in 2015 by the local council. Can you please explain the legal basis of how you were granted this 24 square meter land plot? And how did you receive it? Did you personally apply for this land plot, and how was it granted to you?
So I provided the proofs to this question, and regarding also my ownership right to this land plot. So that land plot is situated next to a residential multi-story building, and beyond me, 16 more people got those land plots living in the residential complex. Just like me, they wanted to use it. They wanted to use it for construction of a garage. And under the law, each citizen has a right to get land plots for certain purposes with certain dimensions, and that land plot was compliant with the law and even was much smaller than it was possible under the law. And based on the decision of the local council, I received the ownership of this land plot.
I'll look to my colleagues here in the room. And also on the screen, if there are any questions. I can see Gabrielle nodding no. Thank you, Mrs. Inna Anatoliyivna. It's been a pleasure speaking with you, and I will turn it back to the chair and the HQCJ.
Thank you, Jessica. Back to you, Chair.
Дякую. Передається слово
Thank you.
Руслану Михайловичу, будь ласка.
Over to Ruslan Mikhailovich. You've got 20 minutes.
Менше.
So I actually have fewer questions. Rapporteur from the PCIe
Дякую.
asked the questions that I wanted to ask. Thank you for your answers and your explanations. There is one aspect that I would like to clarify for all of us. Your vision and your understanding of the issue. You applied to many competitions, to the Supreme Court, the Appellate Court, to the previous competition, to the Hague Court. And in neither, that is, in no competition you were allowed to participate in the interview, but that happens. And I would like to talk about a different competition where you ran, and it is somehow different. In 2021, competition to the Specialized Anti-Corruption Prosecutor's Office. You, being a very experienced judge, it is clear for me why would you run in competitions to the Cassation Criminal Court, Supreme Court, Courts of Appeal, Hague Court, but a Specialized Anti-Corruption Prosecutor's Office is a detour that a judge is taking. It is logical, though, for prosecutors to seek those positions. Could you explain your motivation to participate in the competition for a position, the Specialized Anti-Corruption Prosecutor's Office? Even though you were denied admission to the interview stage, you still participated there. What was your driver there? Yes, sure. Whenever I take a decision, I should be able to explain it, at least to myself. So at the time when I applied to that participation in that competition, I reasoned in the following way. So I knew that the competition to the Hague Court was approaching, and I expected it to be sooner. And human mind works in a way that it should be getting ready to alleviate anxiety and excitement. So I decided to prepare myself for the Hague Court competition by participating in the SAPO competition. I knew that expectations of the public, of society, were very high regarding the Hague Court judges, and I actually scored a good amount of points in the competition for the SAPO positions. Also in the cognitive ability test. So for me, it was just a preparation stage for the upcoming Hague Court competition. Okay, thank you. I've got no more questions at this time. So when answering Jessica's question, you said that you would like to develop professionally. Working as a Hague Court judge is complex. What contribution could you make to this work? What can you bring to the table? So I believe that what matters for each judge is being impartial and neutral. And I'm sure that I will do it. I'm capable of it. My work at my thesis, where I studied electronic evidence, will be of great importance for the Hague Court because studying electronic evidence makes up for a big chunk of work of Hague Court judges. I can contribute my knowledge, skills, and my willingness to make impartial and neutral decisions.
Щодо з'ясування навичок, ви
Okay, so regarding skills,
знаходяться.
we've heard about the proceedings that you had a crime under Part 1, Article 191. Is it does it lies within jurisdiction of the Hague Court? So it's about embezzlement and abuse of power. We need to have the official. And can an official commit this crime? Yes, they can, unless they abused their power. Otherwise, they cannot be adjudicated by the Hague Court. Thank you for your answer. Just a follow-up question.
Ви вказали, що чоловік був
You said that your husband was a nominal owner of the property. Was it a titular owner? Was it the wrong term that you used? So, who was the beneficiary owner? That was my question.
ну, там же ж і переклали. Розумієте, колегам, що не
Because, yeah, the interpretation also was nominal rather than beneficiary. Then another question regarding your thesis, and I would like to give positive feedback. And I have a question. How is it possible that an author doesn't quote their court rulings in their thesis, and you did the opposite? You quoted a lot of court rulings in your thesis. So we've got data regarding the use of electronic evidence in different cases, and a questionnaire 1,289 lawyers took up that questionnaire from your thesis. How did you organize such a large-scale questionnaire? So actually, the scientists involved in my defense were surprised by the same fact. So I turned to different courts, to the Supreme Court, I turned to HQCJ, I sent out letters, emails to facilitate the participation in this questionnaire, and it's easy to check it. I have all the links and all the answers. All the answers were provided electronically. It is easy to check. So this is also an electronic evidence, piece of electronic evidence. I would like to state that Nadia Kubecka joined the commission, and Melnik, as well as Hatseluk. That is for the minutes of the session. And another question from our colleague. Good afternoon. I have a couple of questions. I would like to get back to the issue with your office. Could you clarify that for me, please? So you say that it was an ordinary situation, but from your explanation, you performed your functions as a court chief in the office that was not designed for the court chief. What did you mean? So what I meant was there is a plan of every building for the chancellery, for different offices. And when I started working as a judge, court chief, that plan was already there. So as a court chief and later as a judge, I was in an office that was not intended for the court chief office. There was no such office in our court. Is it a non-typical office in a court? So was it a post-Soviet court building? Yes, indeed. So in districts, they would construct typical court buildings. And your building is non-typical. Exactly. So there were attempts to evict you from that office. Is this correct? Yes, it is. You've got 3 judges in your court. Every judge had an office. But then why would they evict you? Who would get your office? So it wasn't about any future decisions. They were just trying to evict it. So there was a conflict. Otherwise, we cannot comprehend this situation. Well, I don't know what they wish to have that office for, but someone had ambitions to occupy that office. So in fact, after that, we managed to maintain a constructive relationship. So after you filed a complaint to the High Council of Justice, well, for me, what matters in that situation, it is an unpleasant situation. That is obvious that it is unpleasant. It's important to say it because every one of us does something and analyzes in hindsight. Would you do the same thing? And I know today that I would do the same. So did you stay in the same office? Yes, I did. Regarding your declarations, we started your declarations for 2023, 2024, and in declaration for 2024, did you have any significant purchases? I haven't seen any changes in property or cars. In 2024, no.
No, you did not submit notifications, no? But if we compare the financial assets, they significantly decreased for you. In expenses and in legal transactions, in section 14 of the declaration, where you have nothing to declare, but you have a significant decrease. Currency and hryvnia savings. If possible, can you please explain? Then it happens that you spend money on something. I will not look for the declaration, but if you pay attention there, I just do not remember the year specifically, but I had funds for on my card account in currency. Then, accordingly, I withdrew that money and I kept them in cash. I did not have any significant expenses during that period of time, but one of the expenses was, for example, I was taking my son in 2024 to Cyprus. Okay, then I will ask a direct question. Your car was bought on credit. Yes. Yes, I've recalled. During this period of time, you just don't remember that. During this period of time, my car was on credit. When I was buying that, that was a beneficial credit. So for some period of time, for 2 years, 0.1%. Yes, yes. And then either 15 or 18%, so a significant increase of interest. And I spent this money to repay this loan early because it was issued for a longer period of time. Thank you. That's what I wanted to ask. I just do not remember years. Yes, I know that I didn't buy anything. Yes, that it happens according to the declaration. Yes, you just reminded me. Thank you so much. Thank you. No more questions.
Це немає більше запитань.
No more questions?
Дякую.
Okay, thank you.
Колеги,
Thank you, colleagues. Inna Anatoliyivna, you have up to 1 minute to maybe provide some additional information that you have not informed yet to the Commissioner or the PCAE. Thank you so much, dear members of the PCAE and dear members of the HQCJ. Thank you for this interview held. I have nothing to add. Thank you for your tolerant attitude and for friendly attitude, and have a good day. Thank you. Likewise, have a good day. Thank you for your participation in this interview. It's over with respect to you, and I'm announcing a break. The broadcast is off.